Yeah, so what you would look at is see if Dan Springer has the original.
That's kind of what we're asking.
And that's who you would get through that. Because
Okay.
this actually came to us through the county attorney, not
Okay.
from Dan himself.
I see.
So you would have to ask him. And basically what would happen is in court or no record, you know, like anytime that there's if there's a traffic stop and the person comes in and
Sure.
pays the traffic stop, the officer
Sure.
may not know that and still do a report.
I see.
So a supplemental report is supplemental information, so it's not unusual to have.
Okay, and I might alert you to the fact that the 27th and the 4th, that's over a week, so I'll just let you know about that.
Yeah.
That's over
and
a week.
that's not unusual
That's
for
not
officers.
unusual. Okay.
Right. You know, because like if an officer does a DUI arrest, he arrests somebody on the
Sure.
27th.
Might take him a couple of days to fill it out.
He'll do the affidavit of probable cause that day, but then he might need to download and review his video camera,
Okay.
and it might, and then when he downloads and reviews his video camera, he'll do the report.
I see.
But his call duties and different things like that might be heavy enough. It may take him 3 or 4 days to finish.
In the case that the example you've given, you were talking about like a traffic ticket.
Right.
That would not have been adjudicated at that point, though.
It could have been because the
Could have
person,
been.
right? Because
Okay.
the person could have come in and pled guilty.
I see.
Because they have a citation.
And he doesn't know about it because lack of communication.
Right, because the paperwork.
I got
Well,
you.
not lack of communication. What happens is that the officer writes the ticket, right?
Okay.
And then the person comes in, like let's say it's a Saturday,
Okay.
and they come in on a Monday and plead guilty to it.
Okay.
But the officer doesn't know that yet, because his ticket, we have to process all that information and all the sentencing and different things like that, and then we do a return to the county attorney, and we send a copy to the county attorney and to the sheriff.
I'm still a little unclear about it, but I understand what your explanation is. I guess where I'm requiring some clarity is we have apparently a supplemental information report that's filed approximately 7 days after a case that was adjudicated, and I'll just let it go, but I'm just kind of puzzled about that.
This is when the officer has the ability to sit down and actually
Okay,
write.
you can see my concern,
Sure.
my puzzlement. Okay,
I
thank you.
understand. I don't understand the concern. I understand what you're saying, but as far as the
my concern is that
somebody supplementing a report of something that happened on the 27th, they write the report on the 2nd. Of what their recollection of the events of that day. As to, Deputy Springer or Under Sheriff Springer would be the person to ask as to why the delay.
Okay.
But it's not unusual.
Is there a method I would do that to ask Deputy Springer that?
He should
Just
be
talk to
upstairs.
him personally?
Sure.
I can do that as a member of the public?
I think so.
Okay.
Yeah.
I have a
Thank you.
question.
Sure.
What kind of purpose could be served of filing a document with the court that's unsigned?
Well, that's a good question, and that's one for Under Sheriff Springer.
Okay.
Because
And,
you're asking me to give validity to the reports, and I don't do that.
Right, I understand.
If it's an unsigned document and somebody wants to bring that into question, that's what court's for. And whether or not it would stand as it's part of the file because it's been submitted.
Right.
We don't give validity to this or that
Sure.
unless it's an order from me, and that's usually a decision. Things that are filed are part of the file. As to what part of the file and what they play in the file, that has to be played out yet. So if there's some questions and some of the validity because it's unsigned, I'm not saying it's a valid report. What I'm saying is we received a report. So you would have to go up to Deputy or Under Sheriff Springer at the sheriff's office and ask him as to what validity his report has if it wasn't signed. But that'd be a fair question for him and not really a fair one for me, as I'm not giving validity. The file, nothing's been adjudicated except for the contempt in this file. Ernie's innocent until proven guilty, and it's the state's burden to prove him guilty beyond a preponderance or beyond a reasonable doubt.
And you're not saying anything about the document's validity because that's not your province at this point in time?
Correct.
Okay.
And no, other than you, nobody's called into question the validity.
And I'm glad that you've noted that we have called it into question.
Sure.
Thank you.
And
Appreciate
the thing
that.
is that that's something you can bring up with Deputy Springer.
Okay.
But the other part is the supplemental
Sure.
being done afterwards.
I think I'm a little more clear on that.
Sure. But this here obviously has a date and it's signed, and that was the sentencing on the contempt.
Right.
That is the final conclusion.
Okay.
So the sentencing order has validity.
Sure.
Okay, in this court. Now, it has the ability within a certain amount of time frame to be appealed and those types of things. Those are things that Mr. Telgte would have to do.
Is the contempt in your presence appealable?
The sentencing can't be.
Okay. But the charge can't be because you've adjudicated it in your presence.
The thing is, though, there are
circumstances that may?
There are other ways to handle the situation, sure.
Okay.
If you're like in Ernie's position, he would be, he would have, I can't give legal advice, right?
Sure,
Tell you.
absolutely.
But there's avenues that he could approach.
Okay, well, and I'm not in Ernie's position, and I'm not speaking for him by any means. And we're doing this simply on our own, independent of Ernie.
And like, I don't mind cameras, and I don't like being videotaped.
I appreciate it.
So.
Well, you've been very, very pleasurable and open to me.
Well, if anything, any of the questions that we have, and understand when something that's in a file is just in a file. Unless it's adjudicated in the courtroom and there's an order by me, it's just part of the file.
Right. Unless you put a gag order on it, it's open.
Well, some stuff will be, some stuff is filed under seal.
Sure.
And that will actually be in here, but in an envelope.
Has anything been sealed on this case? Okay.
No, because that would have to be motion.
Okay.
And usually what it is the defense will file a motion, like if somebody had a evaluation that deals with medical or psychological or any of those types of things that they want that are private, and the right to privacy outweighs the right.
And we're in favor of that too. We're in favor of privacy.
But those are the things that come into play.
You bet. Certain documents are private.
Well, they have to be motion. It just doesn't get done because somebody wants it.
Sure.
There has to be a reason behind it.
It can't be unilateral. It has to be on both sides in front of you.
Section 2, 10 and 11.
You know all that stuff.
Right to privacy and public's right to know.
Article 2.
So
Article 2, Section 10 and 11.
Article 2.
Yeah.
My big question is, I believe, fraudulently refused access to this record on Friday. Now I'm seeing it, and I'm wondering why the change in policy.
Well, there wasn't really, there's a difference in what we're doing here, is that there's no real change in policy, because if somebody files or calls in and wants this information sent to them, obviously we have to take it, we have to redact it. Some of the information like the confidential criminal justice information such as date of birth, social security numbers, any of those types, private stuff. We have to redact that. So anybody that comes to the front window has the ability to see a file, just like you do upstairs from the district court.
I was refused twice on Friday.
I understand.
That's what bothers me.
Yeah, but the thing is that there's, and that was by Terry, and what that was is just a simple misunderstanding as to what there was.
What did you misunderstand?
I talked to the attorney yesterday.
I understand.
And there was a cover-up going on here.
There's no, I take offense to that. What's your name?
I'm a member of the public.
I'm just asking, you asked me my name, I asked you your name.
I was here on Friday.
What's your name?
I was here on Friday, and I was refused twice.
You don't want to share your name?
It doesn't matter. I'm a
Sure
member
it
of
does.
the public, and so
I would like to, I'm not going to use it against you, I just want to know what your name
It
is.
doesn't matter.
Sure it does. Because if you would like to file a complaint, I'd definitely give you a written form. You can file a written complaint, I'll look into it and then get back with you, but I can't do that without knowing your name.
I'd like to have a form if you're offering it.
Okay. Well, we don't necessarily, do you have a statement form or?
I think I have a statement form.
Yeah, we just
I'd
have to
like
do
to
a
law
statement.
too. I understand this goes to the district court too.
How are you?
I'm sorry?
Judge?
I understand the law too. I know this goes to the district court. I know that you're not district court, but I would like to have a form if you've got one.
Sure, absolutely. And then if you want to file a complaint, you can do that. I'll look into it, and then I'll get back with you. Obviously, some of that information, if it's a personnel-related matter, would be confidential as well. But some of it, I'd be
know
able
as
to
well
share
as I
with
do.
you.
I was refused twice, and I'm not refused because we had TV cameras today.
No,
and,
you didn't get refused because I said to give you the file. Because
And we appreciate that.
Because there was a
Appreciate that.
misunderstanding in what the policy really is. That's different than trying to hide
Would you?
something. No, nobody's trying to hide anything, and I like the, I don't mind conspiracy theories either, but there isn't one here. And if there was, I wouldn't be here talking to you, Mr. I don't know.
I'm just going on record saying that I was refused twice.
You're going on your record saying, but you refused to even on your own record say your own name.
I have 3 witnesses.
Well, you've got that too, so, but yet you still won't say your own name.
Everybody knows who I am. It doesn't matter.
I don't know who you are.
I'm a member of the public.
And I am too.
Thank you.
I appreciate it. I would just like to know your name.
Let's part friends.
Oh, absolutely.
Absolutely.
I have no,
Let's part friends.
I'm just asking your name because I'd like to be able to, just in generalities, know who I'm talking to, and I don't have any problems telling you who I am.
Sure.
Those types of things. And as a matter of the public, if you don't want to tell me, I understand that too.
Sure, thank you.
But if you do want the form, we'll definitely get you one, and you can fill that in and send it in to us.
Please.
And we can deal with that. That's no problem. That's what we do.
Thank you.
Yeah.
Thanks, guys.
Anything else?
I'm not quite done with this.
No problem.
Anything.
That goes in there too.
That goes in the file.
Yeah, please don't mix them up.
No,
Don't
yeah.
move them out of order.
I'm careful with that.
See if we can get it exactly the way it was.
Understand.
There's the form that you sent me.
Oh, okay. Yeah, this is, what we'll do is, this is the Judicial Standards Commission. That's if you want to file a complaint against me, but you can have that as well. And that would be against me.
Oh, okay.
And, but I would, you know, you could either write it on just regular form, like